Well, 2012 has been a huge year filled with developments both in the courts as well as the introduction of various pieces of legislation within the realm of workplace relations.
Let's bring you across some of the standout moments with Joydeep Hor from People and Culture Strategies, the principal no less. Joydeep, warm welcome to you. What has to be regarded as quite an incredible sort of development on appeal when it comes to your rights as an employee when doing work outside the office? In this case, in lodgings, overnight, nocturnal activities gone wrong, and oopsie daisy, it's the employer that bears liability. Who would have thought?
Absolutely, a case that brings a smile to the face for so many reasons, I think. But from a legal ramifications point of view, this is the workers' compensation claim where an employee who was travelling for work, that trip paid for, subsidised by her employer, she's staying overnight, she has a liaison with a male friend and sustains an injury, not one assumes directly related to the liaison, but who knows, puts in a claim for workers' compensation.
Yeah.
The debate really from a legal point of view is that conduct that's occurring within the course of employment, and initially that claim was rejected. Many would say that's probably the intuitive or instinctive response, but it's now been approved by the full court of the federal court. They've said, well, look, it's not for us to pass moral judgments on what employees might do. If it's a work trip, as this was, it was not illegal activity that she was engaged in. Is this any different to her sustaining an injury if she was playing a game of cards? And therefore this is considered to be within the scope of employment, at least from a workers' compensation point of view.
Yeah, from that workers' compensation point of view, compensation could be refused if there was gross misconduct.
Correct.
So again, how is that kind of understood now in reaction to this case that we've seen? What gross misconduct
I think if the employee in question was committing fraud or was engaged in burglary or was committing a sexual assault, for example, to take perhaps a more paralleled example or analogy, then that would be considered to be serious misconduct. It wouldn't be compensable from a workers' comp point of view. But this was, from all intents and purposes, consensual sexual relationship, perhaps brief, but...
Is part of it also the public v private debate? In other words, gross misconduct would be more likely to occur or be deemed to have occurred in a public setting. So if we're taking the analogy a step further and say pole dancing gone wrong, that might be considered from an employer's perspective gross misconduct when you're away to do a set job and therefore not entitled. But what goes on behind four walls in a private capacity, possibly there is liability. It's not likely to bring shame. It's
correct. Yeah, perhaps so. They don't seem to draw that much of a distinction from the public-private point of view, at least as far as this judgment's concerned. What I find really fascinating about this, though, is that this has been a theme right throughout this year and will continue to be a theme going into 2013 and beyond. And that is this blurring of the boundaries between what is considered one's private life and what is considered one's work life. And we're seeing this...
Work goes beyond 9 to 5. It's kind of ongoing after that.
Well, that was a wonderful instance with the Lynn Fox situation as well, because there you had, what's considered, where do you blur the lines between what Facebook uses appropriate out of office hours, so you can post and be deemed to be doing that in your private capacity, versus, even in the office, be logged on,
absolutely,
typing away.
Yeah.
How did that one really clarify things?
Another really important case. So we've got a situation where an employee posts clearly inappropriate, racially offensive, sexually derogatory comments about co-workers on Facebook, is unfairly dismissed following an investigation that's considered to be misconduct by Lynn Fox, the employer in that particular case. He wins his unfair dismissal claim, and the finding, and that's approved by on appeal by the full bench, the finding is that the conduct wasn't great, but in circumstances where Lynn Fox didn't have a policy that said that certain forms of behaviour were clearly inappropriate when it comes to social media, and in circumstances where a view was formed that it's almost akin to freedom of speech, and unless you're going to regulate that kind of freedom of speech through an employer policy, the conduct, while not great, did not warrant termination. But what we are seeing is that social media is the domain in which this blurring of the boundaries is most commonly being brought into a point of tension.
How have you been advising clients differently, say, since that case, for example, to you know, to kind of learn from what went on there.
Yeah, I think the easy advice to give employers is make sure you've got your policies in order, because absent those policies, it's going to be very difficult.
Is that kind of get out of jail free territory? You know, you've got the policy, if people don't abide by it, then you kind of...
You've got that fallback, but then there have been plenty of cases this year where employers have had policies, and the criticism has been, well, you had the policy, but you didn't really educate in relation to the policy, or the policy was just a paper policy and it wasn't actively implemented. There was another decision earlier this year where an employee was reinstated for having sworn at his manager, and the view was formed by the Commission in that case that swearing was part of the culture of this particular organisation, and therefore it was somewhat hypocritical for the employer to act on that. So merely having that policy is not going to be enough. It's got to actually infuse the entire culture of your organisation.
Well, speaking of mutual trust and confidence, as you might well then say, let's talk about the CommBank case when it comes to redundancy, summary dismissal, and what you need to be aware of, particularly after long service. There were some fairly extreme steps taken to kind of proverbially pack and exit without necessarily going through all the proper checks to even assure redeployment.
Absolutely, and this is the flip side of the policy point. So the easy advice, as I was saying, is to tell employers, well, you've got to have policies for all sorts of things. In this particular case, the Commonwealth Bank, organisation that has numerous policies that cover pretty much every aspect that you could conceive of in employment, has a policy dealing with retrenchment and redeployment and is found not to have complied with it. Didn't actively explore redeployment opportunities for an employee whose position was made redundant. And the finding by the court, which is a really important one, was that this conduct, leave aside whether it was a technical breach of the policy or not, breached the implied duty that the employer has not to conduct itself in a way that undermines the trust and confidence that it has with its employees. The ramifications of that case, it's subject to appeal as I understand it, the ramifications of that particular case can be taken in all different ways, and we will see that happen subject to the outcome of the appeal next year.
Are you saying that the quantum of damages gets ratcheted up because there's that additional impost that's been flouted?
Well, taking it beyond the express terms of a contract into, well, forget the express terms, let's look at whether you're acting in a fair way. That opens it up for all sorts of interesting...
Does that turn on facts of the case given the length of tenure?
Always, if an employee has a longer period of service, understandably the employer is going to be held to task greater.
In terms of defining moments for 2012, do you think we've covered the main ones, or were there other ones you go into 2013 and say that really changed?
Yeah, I think it's always a developing area, and I think what we've seen, particularly on the legislation side, 2013 election year, lots of speculation about what the coalition's policy is going to be from an IR point of view. We've seen some reforms to the Fair Work Act already. Discrimination laws are proposed to be harmonised. Some radical stuff's being proposed when it comes to discrimination law. We've seen some high-profile examples again this year, high-profile sexual harassment cases, and indeed as recently as last week. So all of these things are going to mean that employers need to be up to date with what their obligations are, need to be better aware of these the changing landscape, and be on the front foot.
Well, you're always here to shed valuable light, and no doubt 2013 will be no different on that score. Thank you so much. Season's greetings.
Thanks very much to both of you as well.
Joydeep Hor from People and Culture Strategies.
That news has been breaking as Joydeep has been with us. Linus shares, I can tell you, we're up about 5%. They have now added